Okay, let's unpack this. Imagine stepping into, like, the operating theater of a real estate transaction, especially here in California. It's far more than just touring homes and thinking about curb appeal. There's this vital, incredibly complex process happening behind the scenes. Precision, transparency, they're non-negotiable.
Absolutely. Think of it like this. The house showing, that's the initial consultation. But the transaction process, that's the detailed procedure itself. Every single step matters. Every form has a real purpose. And handling it correctly is just key to a successful outcome.
And today we're taking a deep dive into your sources. We're exploring everything from the strict timelines and money handling rules to the absolutely critical world of disclosures and even some, well, pretty eye-opening data on fair housing.
Yeah, our mission is really to pull back the curtain, help you understand the immense responsibilities real estate professionals carry day to day. We're looking at how they manage client funds, which is a huge, huge trust.
Right.
And why being a truth teller through these mandatory disclosures isn't just, best practice, it's the law. And it's fundamental to the integrity of the whole deal.
Right. It's like learning how this complex machine works so you can truly appreciate why all those intricate parts are essential for fairness,
Yeah.
to protecting everyone involved. So let's jump in. Let's start with the basic rhythm of a transaction, the contracts, the timelines, and how the money flows.
Okay, so your sources make it crystal clear. California real estate contracts often declare time is of the essence.
Which basically means deadlines aren't suggestions, are they? If a date slips by without action, there can be, like, real consequences.
Exactly, and any little tweaks or changes to that contract, maybe an extension on inspections, they need to be in writing, signed by both the buyer and the seller. No verbal agreements changing critical dates or terms, that won't fly.
Makes sense. Get it in writing. Always. Okay, so the sources give a sense of the typical choreography here, the timeline.
They do. You usually see the buyer needing about, say, 3 days to get their initial deposit, the good faith deposit, into escrow.
Okay, deposit into that neutral third-party escrow. Got it. Then what's usually next on the clock?
Around 7 days is pretty common for the buyer to get their loan applications fully submitted and also provide verification that they actually have the funds needed to close, proof of funds.
So proof of funds and getting the loan process really moving forward, all within that first week or so. What about digging into the property itself, the inspections?
That's often a 17-day window. This is the buyer's big inspection and investigation period. And they're not just checking the physical condition, the roof, the plumbing. They're also looking into things like its insurability. Can they actually get homeowners insurance? That's critical.
Right. 17 days for all that due diligence.
Mm-hmm.
Meanwhile, the seller has their own homework, right? Things they need to provide.
Correct. The seller typically has about 7 days to gather and deliver all the legally required disclosures to the buyer. And this is a massive part of that truth teller role we're going to talk more about.
Okay. And these deadlines, they're usually tied to contingencies, right?
Yeah.
Conditions that have to be met for the deal to actually proceed. So removing those contingencies.
That also must be in writing. No surprise there. There are standard forms for this, like the CAR contingency removal form, the CR form. This written removal basically signals, okay, buyer's satisfied with their investigations or the loan approval, and they're moving forward. Often makes their deposit non-refundable at that point.
Okay, so what if someone isn't performing, according to the agreed upon timeline?
Mm-hmm.
Maybe the buyer hasn't removed a contingency or the seller hasn't coughed up a required disclosure.
Well, the other party can issue what's called a notice to perform. It's a formal heads up. It basically says, hey, you have X amount of time, often it's just 24 hours to meet your contractual obligation, or I have the right to cancel this whole thing.
Ah, the notice to perform. And cancellation. It sounds like it isn't simple, especially when it comes to that initial deposit sitting in escrow.
You got it. While you can cancel after properly issuing a notice to perform and that deadline passes, actually getting the deposit funds released from escrow, that requires written agreement from both the buyer and the seller if they don't agree on who gets the money. It can be tied up in escrow indefinitely until they sort it out, or, a court has to decide.
Wow. That really highlights just how crucial escrow is, acting as that neutral holder of funds and documents.
Exactly. The contract itself names the specific escrow holder agreed upon, and it spells out how the escrow fees and title insurance fees will be split or paid. It's like the financial traffic cop for the transaction.
And the costs involved, they go beyond just the purchase price listed on the contract, right?
Oh, absolutely. Your sources mention things like county transfer taxes, maybe homeowners association transfer fees if it's a condo or in a planned development, and sometimes homeowner warranty plans. The contract assigns who pays for each of these specific items. So the final amount a buyer needs to bring to closing is the purchase price plus all their closing costs and any financing expenses.
So you definitely need more cash than just the price tag suggests. Okay, handling all this money obviously requires immense trust and responsibility from the real estate professionals involved.
It's a massive deal. Real estate brokers often manage client funds and special trust accounts, and the California Department of Real Estate, the DRE, they regularly audit these accounts. It's serious business.
And what kind of things do those audits typically turn up? Are there common slip-ups?
Well, your sources note that audits sometimes find violations, often related to, say, proper record keeping or ensuring the broker has evidence of financial responsibility, things like bonding or insurance. This protection is specifically designed to cover the public if there's, God forbid, employee theft or fraud. It's a critical safeguard against the potential misuse of those client funds.
Okay, so it sounds like the DRE is really focused on making sure those trust accounts are truly trustworthy, that the public's money is safe.
That's precisely the goal. And the responsibility gets even more detailed when brokers are involved in arranging certain types of loans, especially those involving multiple private lenders, sometimes called fractionalized loans.
Fractionalized, wow, okay. What's the key requirement there to protect those private lenders?
The sources highlight some really strict rules. Their investment, their money, must be secured by a recorded deed of trust against the property, and that deed has to be recorded promptly, usually within 10 days. This ensures their interest in the property is legally documented and protected right from the get-go.
And what if it's a construction loan arranged by a broker in that kind of multi-lender scenario?
Even tighter controls. An independent, neutral, third-party escrow holder must be the one to disperse the construction funds. The broker themselves can't handle the draws, the payouts. Disbursements have to follow a verified schedule, and often they require certification from a qualified professional, like an architect or engineer, confirming that the work's actually been completed before any more funds are released.
Wow, so many layers, all designed to ensure that the funds are handled correctly, securely, transparently at every single stage.
Exactly. It all underscores that guardian aspect of the professional's role, particularly when it comes to handling other people's money. And speaking of protection and integrity, that brings us squarely to the agent's absolute duty to be a truth teller through mandatory disclosures.
Right. This feels like the real backbone of the transaction's integrity. What exactly is this duty to disclose?
Well, in California, agents and sellers have a fundamental legal obligation. They have to disclose all material facts known to them that could reasonably affect the property's value, its desirability, or how the buyer intends to use it. It's not passive. It's not enough to just let the buyer look around and figure things out. They have to actively share critical information.
And the main way they fulfill this duty for residential properties. Is there a key form?
Yes. For residential properties, 1 to 4 units, the cornerstone document is the Real Estate Transfer Disclosure Statement. You'll hear it called the TDS all the time.
The TDS, okay. I imagine that covers quite a bit about the house itself, like what's working and what's not.
Oh, it's comprehensive. It asks the seller to disclose the condition of appliances. Major systems like heating and cooling, the roof, plumbing, electrical, even things like whether water heaters are properly braced against earthquakes. Your source specifically notes that's a required check. It also requires disclosing awareness of significant issues like easements crossing the property, past repairs, any unpermitted work, known code violations, or if the property sits on fill dirt.
So it's basically a detailed report card on the known condition and the history of the house, coming straight from the seller, verified by the agent's own inspection, too.
Pretty much. And your sources point out something important. Sellers and agents can actually limit their potential liability by obtaining and providing reports from qualified experts. Think like a licensed pest control company or a structural engineer. Providing those expert reports regarding the property's condition shows diligence. It shows they went the extra mile.
That's smart. Rely on the experts when needed. But the TDS, that's not the end of the disclosure story, is it? I gather there are many specific hazards and conditions that need their own separate disclosures.
Oh, absolutely, yes. The disclosure landscape in California is extensive, partly because we have a range of unique factors to consider here. For instance, if the home was built before 1978, there are very specific federal requirements regarding lead-based paint.
Right, lead paint. So disclosing any known lead paint or potential hazards.
Precisely. Sellers have to disclose what they know, provide any relevant reports they have, and critically, give the buyer a specific window of time, usually 10 days, to conduct their own lead tests if they choose. You even have to give them an official EPA pamphlet explaining lead hazards and get signed confirmation they received it. It's very prescriptive.
Very specific steps. And being an earthquake country, California, I assume that's another major disclosure area.
Mandatory. Absolutely mandatory. For certain older homes, specifically pre-1960 wood frame homes or pre-1975 unreinforced masonry buildings, sellers must provide specific earthquake safety guides published by the state. On top of that, agents and sellers must disclose if they have actual knowledge that the property is located within an officially mapped earthquake fault zone or a seismic hazard zone.
So you actually have to check the official maps.
Yes, and your source gives some really strong advice here. If the official maps are unclear about whether the property falls within a designated zone, the guidance is to mark the disclosure form as yes, it is in the zone, unless you have an expert report stating definitively that it is not. Basically, when in doubt, disclose. That's the safest and most legally sound approach.
That when in doubt, disclose principle seems like it applies across the board here, doesn't it?
It really does. It's the core philosophy. Beyond earthquakes, there are also mandatory natural hazard disclosures for things like properties located in designated special flood hazard areas or zones that could potentially flood if a nearby dam failed. Again, usually based on official government maps.
Okay. What about environmental issues, things like asbestos or radon?
Well, the TDS asks generally about seller awareness of hazardous substances, but providing California's specific environmental hazards pamphlet can help satisfy part of this disclosure duty, especially if the seller is aware of potential concerns like asbestos, radon gas, lead, or contaminated soil.
And local rules, do they factor in?
Yes, absolutely. Agents need to disclose if there are any local ordinances that might require, say, energy retrofitting, like installing low-flow toilets or smoke detectors as a condition of the sale. Buyers need to know about potential required upgrades and costs.
Huh. There's even something related to public safety databases mentioned in your sources, right?
Correct. For residential properties, 1 to 4 units, both leases and sales contracts must include a specific notice about the Megan's Law database. This notice informs buyers and tenants that this database exists, allowing public access to information about the location of registered sex offenders. It tells them how they can access it themselves. It doesn't identify anyone, just points to the resource.
Okay. That's a lot about the property itself and its surrounding environment. What about properties in HOAs, condos, or planned developments?
Common interest developments, or CIDs. Yes, they require a pretty significant package of disclosures all their own. Prospective buyers are entitled to receive a whole stack of documents, the HOA's governing rules, like the CC&Rs and bylaws, detailed information on the association's financial health, including the budget, the reserve study, which shows money set aside for future major repairs, current assessment amounts, any known violations by the current owner that haven't been fixed yet, and crucially, details on any past or present construction defect litigation the association might be involved in.
Wow, that's a really deep dive into the health and governance of the community itself, not just the individual unit or house.
Exactly. You need to know what you're buying into. And the disclosures aren't just limited to property condition or community rules. There are also disclosures related to the transaction itself.
Like potential tax implications.
Yes. Your sources mention the FRPTA and California withholding requirements. In certain California transactions, the escrow holder is legally required to notify buyers that they might have a responsibility to withhold 3 and 13% of the gross sale price for state income tax purposes and send it directly to the Franchise Tax Board. It depends on various factors, like if the seller is exempt, but the buyer has to be alerted to this possibility.
And protecting the buyer's actual ownership, their title.
Title insurance is absolutely key there. If, for some unusual reason, no title insurance policy is being issued as part of the escrow process, then both parties in an exchange, or just the buyer in a standard sale, have to sign a specific notice. This notice acknowledges that obtaining title insurance is highly advisable because there could be hidden prior recorded liens or other encumbrances affecting the property's title that aren't immediately obvious. It's a strong warning.
That seems like a critical warning to provide. Okay,
Yeah.
so beyond property specifics and potential issues, Agents also have to be really transparent about who they actually represent in the transaction, don't they?
Absolutely fundamental. This is the agency relationship disclosure. Agents must clearly state in writing whether they represent the seller exclusively, the buyer exclusively, or potentially both parties acting as a dual agent. And they must get written consent from all the parties they represent. This ensures everyone involved understands exactly whose best interests that agent is legally bound to uphold. No confusion about loyalties.
Transparency about loyalty. Makes sense. And there are financing disclosures, too, beyond just the basic loan terms.
Yes, especially if the agent or broker is involved in the financing side in some way, like arranging a private loan or maybe selling a promissory note secured by real estate. There are specific disclosure statements required for potential lenders or purchasers of those notes before they commit their funds. And under federal law, specifically REALTORS, the Real Estate Settlement Procedures Act, there are more disclosures, like the affiliated business arrangement disclosure. If an agent refers you to a service provider they have an ownership interest in, say a title company or mortgage broker, they have to disclose that relationship and explicitly state that you are not required to use that affiliated provider. You can shop around.
So you don't have to use their cousin's pest inspection company, even if they recommend them.
Exactly right. RESPIA also mandates the use of standardized settlement statements. Historically, the HUD one. Now, often, the closing disclosure, or CD, which itemizes all the costs associated with the transaction. And you, as a borrower, generally have the right to review that closing disclosure at least 3 business days before you're scheduled to close. Plus, loan applicants have rights regarding their credit. They can see their credit score, the key factors impacting it, and their actual credit report.
The sheer volume, the specificity of all these rules and disclosures, it's almost mind-boggling. Why? Why put everyone through all this paperwork in detail?
This is where that guardian role we talked about really shines. All these disclosures, all these rules, they're designed fundamentally to create a foundation of transparency. The ultimate goal is to prevent problems down the road, misunderstandings, disputes, even lawsuits, by ensuring both the buyer and the seller are entering the transaction as fully informed as possible based on all the known material facts. It levels the playing field.
Okay, so what happens if an agent doesn't disclose something they knew or should have known? What are the potential repercussions?
Well, that can lead to some pretty significant consequences. Regulatory bodies like the DRE, the Department of Real Estate, and also the California Civil Rights Department, the CRD, at the state level. Along with HUD, the Department of Housing and Urban Development, federally, they vigorously enforce these real estate and fair housing laws. Agents can face disciplinary actions from the DRE like fines, license suspension, or even revocation in serious cases. Plus, they can be sued in civil court by parties who were financially harmed by that failure to disclose.
Speaking of the CRD and upholding fairness, your sources also dig quite a bit into California's fair housing laws.
Yes, and this is critically important. California's fair housing laws, which are enforced by the CRD, are designed to ensure that everyone has equal access to housing opportunities free from illegal discrimination. And the law prohibits discrimination based on a really wide range of protected characteristics.
We know the common ones like race, gender, disability. What else is protected specifically in California?
It's broad. Race, color, religion, sex, which includes gender identity and expression, sexual orientation, marital status, national origin, ancestry, familial status, having kids, disability, mental or physical, genetic information, veteran or military status, and importantly, source of income. Your sources specifically highlight that prohibiting discrimination based on source of income means a landlord or agent generally can't refuse to rent to someone just because they use a Section 8 housing voucher or other forms of public assistance to pay rent.
Source of income is explicitly a protected class here in California housing law.
It absolutely is. And these fair housing laws apply very broadly, not just to agents and landlords, but also to lenders, insurance companies, appraisers, and even local governments in how they handle zoning regulations or building permits.
So what are some concrete examples of discriminatory actions these laws prohibit?
Oh, things like refusing to sell, rent, or lease housing based on a protected class, or imposing different terms, conditions, or privileges like charging a higher rent or deposit, misrepresenting the availability of housing, telling someone a place isn't available when it actually is. Also denying reasonable modifications to a property for a person with a disability, like allowing them to install grab bars at their own expense, or refusing reasonable accommodations in rules or policies, like allowing a service animal in a no pets building. And it covers discriminatory advertising, too.
Your sources also touched on tenant screening practices, didn't they? Specifically regarding criminal history.
Yes, that's a very nuanced and evolving area. While housing providers can consider criminal history in assessing applicants, there are significant limitations under California law and federal guidance. They generally cannot consider arrests that didn't lead to conviction, participation in diversion programs, convictions that have been sealed, dismissed, or expunged, or juvenile records, and crucially, they can't have blanket bans that automatically exclude anyone with any kind of criminal record. Any screening policy must be tailored to consider the nature and severity of the crime and how long ago it occurred, and it must be applied in a way that doesn't have a disproportionately negative impact, a disparate impact based on protected characteristics like race or national origin.
That's a very careful balancing act, trying to ensure community safety while also promoting fairness and avoiding discriminatory outcomes. How common is housing discrimination in reality? Do we have a sense?
Your sources include some interesting data from a survey conducted in San Bernardino County, which gives us at least a local snapshot. It showed that a notable percentage, 16.8% of the survey respondents, reported that they believe they had experienced some form of housing discrimination.
Wow, nearly 17%. That's quite significant. Who did these respondents identify as the source of that discrimination most often?
Well, of those who reported experiencing discrimination, landlords and property managers were cited most frequently. However, 9.8%, almost 1 in 10 of those experiencing discrimination, pointed specifically to a real estate agent as the source. So while not the most frequent source in that survey, agents were definitely identified as being part of the problem for a meaningful number of people. The data confirms it's something people encounter across different players in the housing market.
And did most people who felt they were discriminated against actually file a formal complaint?
The data suggests, unfortunately, no. Only a very small percentage of those who believe they experienced discrimination actually went through the process of filing a formal complaint with an agency like CRD or HUD. The most common reasons people gave for not filing were things like they didn't know how to file a complaint, they didn't think filing would actually help or make a difference, they feared retaliation from the landlord or agent, or, quite significantly, they weren't even aware that the action they experienced was actually illegal discrimination under the law.
That's really powerful, that lack of awareness about rights and also fear can be such major barriers to people seeking justice or enforcing their rights.
It really is. And the survey had another interesting finding. Participants who identified as senior citizens and or persons with disabilities were actually slightly more likely than other groups to report experiencing discrimination. But paradoxically, they were less likely than others to file a formal complaint about it. This might suggest there are additional hurdles or perhaps different kinds of fears for potentially more vulnerable populations when it comes to navigating the complaint process.
So this whole deep dive, it's really underscored that a real estate transaction, particularly here in California, isn't just some simple exchange of property for money. Far from it.
Not at all. It's a highly regulated, really multi-layered process. It's built on strict contractual timelines, the careful and ethical handling of significant sums of money held in trust, and, maybe most importantly, this extensive, intricate framework of mandatory disclosures.
All of which seem designed fundamentally to ensure transparency, to try and prevent future problems, and ultimately to uphold a standard of integrity and fairness for everyone involved in the transaction. And the agent's role as both that meticulous truth teller providing all that required information diligently, and also as a kind of guardian navigating the complexities, protecting the parties, upholding the rules, seems absolutely central to making this whole system function.
It truly is. They wear multiple hats, and the responsibility is immense.
So considering just how much complexity there is, how many regulations, how many forms, how many disclosures we've just touched on, here's something to maybe leave you thinking about. With all these protective measures and disclosures theoretically in place to ensure fairness, does the sheer intricacy and, face it, sometimes intimidating complexity of navigating a modern real estate transaction itself, perhaps inadvertently, end up creating significant practical barriers for certain individuals or communities who are just trying to access housing?